President Biden's son, Hunter Biden, has been indicted on 3 federal gun charges. He is now facing up to 25 years in prison. His attorney spoke out yesterday.
This office has never brought a charge like this against anybody. Therefore, you have to ask what changed. It is the folks like Chairman Comer and the Republican MAGA crazies who have been pressuring this U.S. attorney to do something to vindicate their political position. And guess what? They succeeded.
As many of you know, the president's son, Hunter Biden, has been under investigation for over 275 years. Apparently, the Justice Department has finally decided that it was the appropriate time to go ahead and levy charges. Now, most people remember that a few months ago, Hunter Biden had actually entered into a plea agreement, and at the very last minute, that plea agreement completely disintegrated. And many people thought that the plea agreement was unreasonably lenient on Hunter Biden. And in fact, that there was some sort of political, overtones associated with, the plea agreement from the beginning. That notwithstanding, the special prosecutor was named, and now there's been a formal indictment levied in the state of Delaware. Now, these are federal gun-related charges, and it'll be interesting to see how this actually continues through the court system, because I do believe that Mr. Biden has some very strong defenses, constitutional defenses, that actually could benefit all of us as gun owners. To tell you the truth, right at the very beginning, Mr. Biden will most assuredly be arguing that the underlying statutes of which he's being, held to answer for are in fact violations of constitutional law, that they abrogate the Constitution under a Bruin analysis. And he has some authority for that. In one of my previous videos in another circuit, in the Fifth Circuit Court of Appeals, in a case called U.S. v. Daniels, we had a very, very similar case. In that case, we had Mr. Daniels get arrested for being in possession of a firearm while admitting that he was a habitual user of marijuana. Now, in this particular case, there's 3 counts. In the Biden case, there's 3 counts. Count number 3 is identical to what Mr. Daniels was charged with. In count number 3, the state is making the argument that Hunter Biden is an abuser of narcotics, was in possession of a Colt Python, and therefore was violating 18 USC 922, which is essentially the federal prohibition about being a habitual user of narcotics. Well, it's actually the entire Gun Control Act, but it focuses in on habitual user of controlled substances. Well, in the Daniels case, again, not controlling legal authority to Mr. Biden because he's in a different circuit, but certainly persuasive authority. The Fifth Circuit Court of Appeals said this prohibition is unconstitutional and overturned Mr. Daniels' conviction. I suspect that a intellectually honest jurist, would do the same thing on count number 3 of Hunter Biden's potential criminal act. Now, on counts 1 and 2, those are what I oftentimes call the perjury trap. Basically, they're claiming that he lied on the 4473 form. And for anyone who's ever purchased a firearm in the United States, you have to fill out a federal document at the time of transfer. That document produced by the ATF is called a 4473 form. And on that document, it asks you whether or not you are a user or whether you're addicted to controlled substances? And your answer on that is subject to criminal prosecution for perjury. Well, Mr. Biden checked no on the box when evidently there is a fairly substantive amount of evidence to suggest that he was, in fact, a user of controlled substances during the time of the acquisition of this Python firearm. Hey guys, I'm pausing this video for just a moment. I want to talk a little bit about a giveaway that USCCA is doing, and what they're giving away is unbelievably cool. You can read all about it in the description just below this video, and definitely click on the link. All right, let's get back to the video. There's a granular question though that comes about, and that is, when is someone actually a user, or when is someone actually addicted? Give you a point of reference. If you have someone who is continually using a controlled substance, has a deeply moving religious experience on Sunday afternoon, and then suddenly decides to swear off all narcotics for the rest of their life, and by Sunday evening, they are now sober with absolutely no intention of ever participating in any sort of illegal narcotic again. On Tuesday, they go to a gun store and the question is posited to them, are you a user of controlled substances? Well, this individual would answer honestly, no. Had they been in the past? Oh yes, absolutely sure if they were asked that question. But the question is very specific. Are you right now? And the answer for that individual is no. Well, let's say 3 or 4 days later, they fall off the wagon and start using narcotics again. The question then becomes, did they lie on that 4473 form? And arguably speaking, at the time that they filled out the document, they were being absolutely truthful. This is one of the fundamental problems, to be quite frank with you, with the 4473 and the question about narcotics. More importantly, if we subject that question back to the Bruin analysis, just similarly to what the Fifth Circuit Court of Appeals did, we have to ask ourselves, okay, at the time of the ratification, were there any laws that prohibited individuals who regularly became intoxicated? And, intoxication is the functional equivalent to drug use. Back then, were there laws that prevented people who habitually became intoxicated from losing their Second Amendment rights? To my knowledge, no such legislation existed. So I believe it would fail the Bruin analysis as well. So I do believe that Mr. Biden has some extraordinarily strong defenses. Now, if he prevails at the district court level, it's almost assured that the state would then appeal it to the Court of Appeals. And frankly, if he loses, Mr. Biden would probably appeal the conviction to the Court of Appeals. This would then create controlling law. A Second Circuit now would also be adopting, assuming that they rule in Mr. Biden's favor, what the Fifth Circuit did. Or alternatively, they would go against what the Fifth Circuit said. And now we would have a circuit split, which would be effectively a direct pathway to the Supreme Court of the United States, because you can't have constitutional law existing in one form in one jurisdiction and another form in another jurisdiction. So Mr. Biden may very well become quite the champion of gun rights, which is fundamentally ironic based on his family history. We'll have to see how this ultimately plays itself out. But the one thing that we could almost be guaranteed is that this will result in probably more charges being filed against Donald Trump, because that seems to be the natural order of things now, doesn't it? All right, as always, if you would like to email me, by all means do so at stephen@artemishq.com. As always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.